In today's video, we will talk about the exclusionary rule and criminal evidence. Hello, and welcome to Ask Professor Price. I have been a lawyer for more than 35 years and a full-time professor for more than 10 years. People studying law or criminal justice or working in the legal or law enforcement fields need to know why some evidence can be kept from being used at trial because it was obtained illegally or improperly. The prosecutor will not be happy if they end up losing the case or having the case dismissed because someone violated the constitutional rights of the defendant. The exclusionary rule has been litigated many times. You can see 4 key cases that dealt with the exclusionary rule. But what is the exclusionary rule? Well, it really is what it sounds like. It's a rule that excludes evidence from being used at trial if it was obtained illegally or in violation of the Constitution. Reasons for the exclusionary rule. Well, courts should not engage in illegal conduct, so they should not get to use evidence if it was obtained illegally. Also, the exclusionary rule discourages police misconduct. Many times, an officer might consider stepping past the boundaries of what they're supposed to do in order to try to catch the perpetrator or seize crucial evidence that they need to prove that the person is guilty. They're trying to do their job, but and they might see something just out of reach, and they know that, or they feel strongly that what the person has done is wrong and that they need that evidence to prove it. But it would be misconduct if, for example, they conduct a search without a warrant in a situation that requires a proper search warrant. Also, we have the exclusionary rule because other potential consequences for obtaining evidence improperly would not be practical. For example, if the consequences would be that the officer would be reprimanded by their superior officer, that might be all well and good, but it doesn't protect the rights of the person whose constitutional rights were violated. As part of the exclusionary rule, there's something called fruit of the poisonous tree. You're probably wondering, why are we talking about plants in a course dealing with constitutional concepts and Fourth Amendment protections from unreasonable searches and seizures? Well, it is a phrase that conjures up an image in the mind, and that's exactly what it's supposed to do. The poison is evidence that is obtained directly because someone violated the defendant's constitutional rights. That's the poison, or the poisonous tree. Fruit, in this example, is derivative evidence obtained because of knowledge gained from the initial illegal search. Both the poison and the fruit are kept from use at trial. So the police cannot violate someone's rights and by doing so discover something that they otherwise would not have found and use that information to then obtain other evidence that they want to use at trial. Exceptions to the fruit of the poisonous tree doctrine being applied in criminal trials are independent source, attenuation, inevitable discovery, and good faith. Independent source is if the prosecution can show that they found the evidence through a totally independent, separate source, that they did not locate the evidence through an illegal, warrantless search and seizure, that is an exception. So if the prosecutor has obtained evidence legally, and the fact that a law enforcement officer happened to do an illegal or improper search and find the same evidence, that officer's actions do not make what the prosecuting attorney found through an independent source unusable at trial. Attenuation. That is one of the exceptions to the application of the fruit of the poisonous tree doctrine. But what is attenuation? Attenuation is when the connection between the unconstitutional police conduct is remote, or it's been interrupted by an intervening circumstance such that the constitutional interest would not be served by suppression of the evidence. So with attenuation, if there was a constitutional violation, but then there was an intervening circumstance, and then later, further in time down the road, the evidence was discovered after the intervening circumstance, the attenuation exception would come into play, and the court would say, wait, because of this being really remote or the intervening circumstance, this evidence will be allowed to be used in the trial against the defendant. Inevitable discovery. If the prosecutor can show that they would have discovered the evidence with or without the improper search, it can fall within the inevitable discovery exception to the fruit of the poisonous tree doctrine. So let's say that the prosecutor can show that in this type of case, they always subpoena certain records of the defendant or the defendant's employer, or they would have discovered the evidence through reviewing security camera footage legally. Various possibilities for inevitable discovery, and that those actions would have turned up this evidence without the illegal search and seizure, the judge might apply this inevitable discovery exception and allow the evidence to come in. Also, good faith. Good faith would be when there was a search warrant, the officer did not know that there was a typo on the warrant, they executed the warrant in good faith without excessive force, and that is how they discovered the evidence, or the evidence that was either the fruit or the poisonous tree, and they didn't do anything improper other than, unbeknownst to them, relying on something that had a minor clerical error. Good faith would allow an exception to the application of the fruit of the poisonous tree. Confessions are often, in movies and in books, considered to be slam dunk evidence of guilt. And in real life, not so much. In reality, confessions can only be admissible in court if they were voluntary and if the defendant's rights were not violated. We're no longer allowed to obtain confessions through torture. It used to be quite common, and in some countries it still is common, to torture people who are in custody until they confess to whatever they've been charged with, whether they are guilty or innocent. So confessions must be voluntary and the defendant's rights not be violated in the American criminal court system. One piece of the evidence that a confession is voluntary is that the defendant received their Miranda warnings before being interrogated when in custody. Miranda warnings arose out of the Miranda versus Arizona case. It was a criminal case against Mr. Miranda. He was not advised of his constitutional rights during the interrogation when he was in custody. He had requested a lawyer and was refused one. He had limited intellect. The officers told him that he failed the interrogation, and they stuck a written confession in front of him, which he signed. Of course, he would not have done that if he had had a lawyer representing him, but they refused to give him one when he requested one. The jury found him guilty after the written confession was admitted at court, because juries are often swayed by signed written confessions. They have this assumption that, well, why would an innocent person ever confess to something they didn't do? Well, if the person has limited intellect and really doesn't understand what they're signing or the implications of it, or was pressured and coerced into signing it, that would explain why they have a signed written confession. The U.S. Supreme Court held that Miranda's rights were violated. Ever since Miranda, police have had to handle interrogations differently. If they're questioning a person who's in custody and they don't want to answer any questions, they don't have to. If they say they want a lawyer, the interrogation must stop and they must get a lawyer for the defendant. The questioning can resume after the lawyer is present with the defendant, and not until. So we've talked about the Fourth Amendment and search and seizure. What does all of this mean? The Fourth Amendment guarantees freedom from what are called unreasonable search and seizure. You need to understand a little bit of history to understand the origins of the Fourth Amendment. When America was a bunch of colonies instead of an independent country, British officers or government officials could just barge into a person's house, ransack all of their things, take what they felt like, and leave. Needless to say, the colonists, who then became the early Americans, felt this was unjust, this was tyranny, and that a person should have a right to be free from unreasonable searches and seizures in their place of residence. So what does make a search and seizure unreasonable? Searches and seizures must be conducted pursuant to a valid warrant supported by probable cause, unless the situation falls within one of the exceptions. In other words, if a warrant was required for the type of search or seizure that the police performed, but they did not have a warrant before they searched and seized the object or objects, or if there was a defect in the warrant or in the execution of the warrant, that is unreasonable. So what would a defect in the warrant be? A typo that has the wrong address would be an example of a defect in the warrant. What about a defect in the execution of the warrant? If the police went to the wrong house, let's say they were supposed to go to apartment 105 and they accidentally went to apartment 106. Or if they searched way beyond the scope of the warrant. For example, if their warrant was for apartment 105 and they searched apartments 103, 104, 105, 106, 107, those would be defects in the execution of the warrant. Now, not all searches and seizures need warrants. Most of them in a residence do. But what about for a person on the street? They're not in their residence. Do the police need to have a warrant to do what is called a stop and frisk? Usually no. The case Terry versus Ohio said that a warrant is not required for a stop and frisk. What is a stop and frisk? That's when the police briefly detain a person on the street, remember, not in their residence, to search them briefly for weapons or contraband. How do police get search warrants? They apply for a search warrant and they attach an affidavit, that is a sworn statement, that asserts probable cause. In other words, they attach a signed, sworn, written statement that gives facts that try to convince the judge that the police have probable cause to believe that they will find evidence of a crime at the location that the search warrant identifies. The warrant should specifically describe the place to be searched and the person or things to be seized. Search warrants must be signed off on by a neutral judge. That's called issuing the search warrant. When they have a signed or issued search warrant, then the police execute search warrants. They must be served in a timely manner. Someone can't come to your door and knock on it with a 3-year-old search warrant. It must be served in a timely manner. The search must be reasonable. They're not supposed to completely ransack all of your drawers and cabinets. No unreasonable force is allowed during the search. Searches must take place at a reasonable time of day. The search is limited to achieving the objective of the warrant. In other words, let's say that they're looking for a stolen 60-inch TV set. Well, they can't go ransacking standard size kitchen cabinets or a medicine cabinet in the bathroom or bedroom dresser drawers looking for a 60-inch TV set because it wouldn't fit in those places. So to achieve the objective of the warrant, to find this 60-inch TV set, they can only search places where that TV set could be found. And finally, they must knock and announce unless there is an exception. There have been some horrible cases that have been on the news in which they just crashed the door in and went in shooting and found out after they killed an innocent person that they were at the wrong address. Knock and announce is almost always required. There are some very limited, very uncommon exceptions. Do all searches and seizures require a search warrant? Actually, no. A lot of the time, the police obtain evidence perfectly legally without a search warrant. If the person at the residence consents to the search, the police can search and they don't need a warrant. If the police search and seize for an item in plain view, they don't need a warrant. What is in plain view? An example of in plain view might be something that is in a person's front yard. Maybe a stolen motorcycle that's right in the front yard. The police don't have to get a warrant to search and seize that vehicle. Or if there's other stolen property and maybe they can see it easily because the windows in the front of the house are open or the curtains are open and the item is in plain view of anyone who happens to walk by. That's the plain view doctrine. Also, incident to a lawful arrest. They don't need a search warrant to search a suspect. Incident to a lawful arrest. The police have the right and the duty to perform a search to make sure that the defendant doesn't have a weapon or contraband when taking them into custody. Anything that they find incident to a lawful arrest can be admissible at trial. Please hit subscribe and the thumbs up icon if you enjoy this video. Also, please feel free to share this video with people you think could benefit from the information. YouTube uses the number of subscribers, likes, and shares in its algorithm to determine which videos show up in search results. And the higher these videos are in the results, the more people I can help. Thank you. So how does the exclusionary rule get used? The court's going to assume that the police followed the rules and acted properly unless the defense raises an objection. The defense usually challenges evidence by filing a motion to suppress, and that's usually done before trial. Then they'll have an opportunity to argue whether the evidence was obtained pursuant to a valid warrant, whether a warrant was required, and whether there were any violations of the defendant's Fourth Amendment rights. That is all best done before trial and outside of the sight and hearing of the jury. After the defense challenges evidence and the prosecution argues against the evidence being suppressed, the judge must then decide whether the defendant's rights were violated. They consider some of the key Supreme Court decisions on this issue when they make their ruling. Please feel free to post in the comments your questions about criminal law or related topics that you would like to see covered in a future video. I cannot provide legal advice about specific cases or situations, but I can offer general legal information for educational purposes. Law students, paralegal students, criminal justice students, and pre-law students, as well as people working as paralegals or in the criminal justice field, are the main audience for these videos, but everyone is welcome to learn about American law and our legal system. Please remember to subscribe so you can get notifications when I post a new video. Subscribing won't cost you anything, but it can help me to reach and help more people with these educational videos. Thank you. If you liked this video, you might like the next video about plea bargains.